justice assistance, through whose support we are able to put on this webinar. So our goals for this webinar today are to give an overview of the new Justice for All Reauthorization Act requirements and what that means for state administering agencies. We're also going to highlight Michigan as an example of an SAA who works quite well with the indigent defense community to show what collaboration looks like between SAAs and the defense community and how to include defenders in strategic planning. I'll start now by introducing you to our panelists. I'm joined today by Deb Matucci, who is the program manager for the National Criminal Justice Association. She oversees the grant to provide training and technical assistance to state administering agencies on strategic planning and the implementation of evidence-based policies and practices. I'm also pleased to be joined today by Nancy Becker Bennett, who works for the SAA of Michigan, and she is the Division Director of the Grants and Community Services Division at the Michigan State Police, where she is responsible for providing leadership and oversight to MSP's writing, coordination, and implementation of federal, state, and private grants available to criminal justice. And last but not least, we are very pleased to be joined by Jonathan Sachs, who started this month as the Director of the Michigan State Appellate Defender Office and Michigan Appellate Assigned Counsel System. Prior to starting those posts, he just finished serving 3 years as the first Executive Director of the Michigan Indigent Defense Commission. So to give you an overview of where we will go from here, for the first few minutes, we'll hand it over to Deb to give us an overview of the changes in the JFAA and how those changes will affect state administering agencies. After that, we'll engage in a guided discussion panel between Deb and Jonathan and Nancy. And the last 15 minutes will explore questions and answers from the attendees. As Cameron mentioned, feel free to type in those questions prior to the question and answer period, and we can address them all during the question and answer period at the end. So with that, I'll hand it over to Deb to walk us through the JFAA changes.
Can you hear me now?
Yes, Deb, we can hear you.
Great. Thanks, Billy. Thanks for the opportunity to join the webinar today and to share some information about the Justice for All Reauthorization Act and state administering agencies. Before we talk about the JFAA and how defenders can engage in the planning process, I'd like to spend a few minutes just talking about SAAs and the role that they play in states, what they do, how to find yours, and how to get involved. And next slide, please. Thank you. SAAs have been around for 50 years, yet they're relatively unknown to many of the justice system stakeholders. President Lyndon Johnson, who served from 1963 to 1969, established the National Commission on Law Enforcement and Administration of Justice. The commission was to study and make recommendations on what to do about rising crime rates in the United States. They published findings in a report entitled The Challenge of Crime in a Free Society. One of the recommendations in the report was that a state administrative agency, or SAA, should be established in every state to be responsible for planning improvements in crime prevention and control and encouraging their implementation. The creation of the Law Enforcement Assistance Administration was also an element of the Act. This administration was designed to provide grants in 4 different components to each of the states: in planning, action, education, and research. Many of the needs that we still see today. Congress passed the Omnibus Crime Control and Safe Streets Act of 1968 to implement these many recommendations, which serve as the foundation of SAAs as we know them today. Next slide, please. So where is your SAA? There are many different structures and priorities of state administering agencies, but a common role for all is to provide invaluable funding for program development and implementation. The SAA is able to serve as a nonpartisan convener of often disparate partners for the purpose of planning across the justice system. In some states, the SAA for all formula or block grants is located within one organization or agency. In other states, the responsibilities may be dispersed over multiple entities, including the Governor's Office, Attorney General, the Department of Justice, Corrections, Public Health and Human Services, and others. One of the keys to engaging successfully is doing your homework to find out which grants are administered by which agency, and then learning a bit about how that agency manages the funds. It's important to know what the expectations are regarding data collection, reporting, how the grant process works, and when you need to engage. Next slide. So some of the roles of the SAA often functions as a problem solver. Uniquely structured as a nonpartisan board, the agency and their governing board most often represent the full spectrum of the criminal justice system, from behavioral health through juvenile justice, law enforcement, courts, prosecution, defense, corrections, and reentry. They can play an important role in looking at the full breadth of the system rather than the compartmentalized view of individual state agencies. The SAA is an important partner to consider when bringing together a large group of stakeholders to impact the justice system. SAAs provide training and technical assistance to communities for strategic planning, justice reform, evidence-based practices in justice programming, and more. The grant funds administered by SAAs, when used strategically, can have a positive impact on system change and sustainability. For example, if you use grant funds to front-load a justice reinvestment initiative, perhaps paying for a jail diversion program or development of pretrial services, this enables the state and local funding agencies to continue to meet the demands of the deep end of the pool while those early interventions take hold. As these programs flourish, savings begin to occur at the deep end, freeing up money to flow back into the interventions and sustain the initiative into the future. Next slide. The Edward Byrne Justice Assistance Grant Program, or Byrne JAG as it's known, is one of the formula or block grants that's administered in every state. JAG allows a wide range of purpose areas for funding, including indigent defense and all of those listed here. Next slide. So some of the changes to the Justice for All Reauthorization Act. The Act, passed in December of 2016, now requires all applicants for fiscal year 2019 Byrne JAG state formula grants to include a comprehensive statewide strategic plan that addresses resource allocation, use of data, and implementation of evidence-based practices. This comprehensive plan must be developed in consultation with a diverse group of stakeholders that are defined in the Act. The plan must describe the evidence-based approaches to be used and illustrate how funding will be allocated. States will be required to update their strategic plan every 5 years. Next slide. Within the Act, there are a number of very specific planning requirements. The comprehensive statewide plan details how grants received under the section would be used to improve the administration of the criminal justice system. The plan should be designed in consultation with local governments and representatives of all segments of the justice system, including judges, prosecutors, law enforcement personnel, corrections, providers of indigent defense services, victim services, juvenile justice delinquency prevention programs, community corrections, and reentry. The plan shall include a description of how the state will allocate funding within and across each of those purpose areas. The plan must describe the process used by the state for gathering evidence-based data and developing and using evidence-based and evidence-gathering approaches in support of those funding decisions. For example, if your data indicates a high increase in violent crime, but your resource allocation is pointed towards prevention or early education without an eye towards violent crime, then your data doesn't support your resource allocation, and that's something that you want to line up in your planning process. The plan must also describe the barriers at the state and local level for accessing data and implementing evidence-based approaches to preventing and reducing crime and recidivism. The plan must be updated every 5 years with an annual progress report that addresses changing circumstances in the state, if any, must describe how the state plans to adjust funding within or across the purpose areas, must provide an ongoing assessment of need, and discuss the accomplishment of goals identified in any plan that was previously developed. The update must also reflect how the plan influenced funding decisions in the previous year. Next slide. The National Criminal Justice Association is the training and technical assistance provider under these new requirements. There are a variety of different TA services that are available under this program, which includes 3 tiers of TTA. Tier 1 is delivery of information through email and phone calls, basic documents and referral to websites. Tier 2 includes direct staff support, might involve customization of some documents, training materials and publications, and perhaps facilitating connections to mentors or other SAAs that can assist you. And Tier 3 is a customized approach to meet your state's unique individual TA needs. In some cases, this may involve providing on-site delivery of TTA. We'll also be providing a series of webinars. We have information posted on the website, and the link is posted there on your slide. We have a newsletter that will feature strategies, challenges, and success stories. We're developing a compendium of best practices, an online resource library that will show you best practices and program overviews from your peers across the state and across all 8 purpose areas. And then some materials available in a toolkit to meet your local needs. For example, a planning timeline or a sample survey that you can use with your stakeholders, a federal criteria checklist, perhaps a sample press release for focus groups you might be doing, and things of that nature. Next slide. More than ever before, these changes create an opportunity for providers of defense services to engage with the SAA and have a voice in justice system planning. The new strategic planning requirement specifically states that the SAA must solicit input from indigent defense, among the other partners. Knowing the grant cycle is an important first step. Grant cycles can be 18 to 24 months from concept to implementation, so it's important to engage early in program design. Despite the requirement that this plan be submitted for 2019, the planning process has already begun in many states. We'll turn the discussion over now to our panel to learn about how they've successfully engaged with the SAA to fund defense services in Michigan. Thank you.
Thank you so much, Deb. That was so incredibly informative and a great lead-in to our discussion with Nancy Becker Bennett, who, as a reminder, is the SAA rep for Michigan and the Grants and Community Service Director for the Michigan Department of State Police, and Jonathan Sachs, who is the Director of the Michigan State Appellate Defender Office. Thank you so much, Nancy and Jonathan, for joining us.
Thanks. So I was going to tell kind of the story of how Michigan started funding indigent defense. It was not always a smooth road, I know Zoe mentioned that we have a great working relationship, and we absolutely do now, but for the first several years of this, it was not so great. We obviously in Michigan have been using Byrne funds to support criminal justice since 1989, as all the other states have as well. In 2009, when the Recovery Act money came to us, you know, everyone got a ton of money, every state. And at that time, we were told by our governor's office that we are going to fund indigent defense. They had a state office in Michigan, and I was given someone's name to call and said, here, you guys are going to fund them. You know, that's sometimes not the easiest way to start a relationship, a working relationship, but so it was really difficult. There was all the SAAs have policies and procedures and ways we've been doing things for a while. Our indigent defense community, the organization, I'm not sure what they were told by the governor's office, but they kind of came in pretty heavy-handed, almost with a sense of entitlement from our perspective, and it was, they weren't really integrated into the disciplines that we had been funding. We had been funding law enforcement, prosecutors, courts, I mean, all the normal Byrne JAG funded areas, but nobody really knew what they were or what they had been doing, and it was almost like they didn't know that they had to come almost welcome themselves into that group. You know, we had strategic plans and everything, but they also weren't thrilled that we weren't giving them a ton of money right away, but we weren't told to do that. And we also, you know, we wanted to develop this working relationship. We needed some evidence that they understood what we were about and how we managed grants and what our expectations were. But they weren't really interested in following our rules. It was new to all of us. And as I said, this difficult relationship continued on for several years. In what we did know about them and what we found out, you know, because we continued to give them grant money, they were great at the grant administration process. They had federal grants of their own. They understood it. They had great grant programs that they were running. They showed us their successes. I mean, we were very happy with their grants and what they were doing, but we had difficulty convincing others of this, especially others in our strategic planning group who represented all of the other disciplines that I mentioned before. So in 2013, we had a new strategic planning process, and we had representatives from each of those disciplines come together. Everyone had to present what they thought were the priorities for their own discipline and how they would help out the other disciplines in the room and how everyone would be able to work better because of what each of them were doing. At the end of the day, we had everyone vote so that we could set our goals based on, you know, 1, 2, 3, and 4, based on a sort of a priority depending on the funding that we were getting. And there was no votes at all for the indigent defense to be part of that strategic plan. So we still funded them. We didn't want to keep them out of it, so we continued to fund them, and we continued to work on that process. In 2015, I think, is when our Michigan Indigent Defense Commission started. It was kind of a new ballgame. We really started to build a relationship with them and work through some of the problems. We saw at that time they understood us. They were willing to work with us. They made changes to their funding proposals with some suggestions that we gave them and some suggestions that we got from the other disciplines as if we were going to fund them, how would this help the criminal justice community in Michigan? You'll see a slide, and I will let Jonathan talk about the details of this, but this slide shows that since 2009, so in the last, 8 years, we have given them $1.3 million. And some of the lessons that we've learned are, you know, indigent defense is not something that's in our faces on a daily basis. In our SAA, I'm not sure about some of the other SAAs, but through the better working relationship, they've really opened our eyes to how they do fit into the criminal justice process. and their importance to that process. And we've appreciated working with them. You know, again, we went through some tough times. I know sometimes that's the best way to start a relationship. You get all the problems out at the beginning, which we definitely did. And now, as I said, we have a great working relationship with them. And some of the takeaways are that communication is really a key. You have to have positive communication because you're all doing what you've always done, but if those two things have never really interacted, it's a soft spot, and you have to do that gently. There was a understanding eventually of the process that we go through with our grant money. We don't get a ton of grant money. You know, even if it increases a little bit or decreases a little bit, that makes huge differences. And we, in Michigan at least, we have 700 plus local law enforcement agencies. We have 83 sheriff's departments. We have, I don't even know how many courts and 83 prosecutors' offices. So we have a ton of locals that we could fund. Our staff, the staff that I have that works on the Byrne JAG and the staff that were working in the State Appellate Defender Office and the Michigan Indigent Defense Commission have worked amazingly well together. They've kind of cut through all of this, all the political issues, and they work great together. They have a ton of cooperation between them. And I think just overall, we've all learned how each other interacts and how we operate, and we've come to appreciate that.
Great, thank you so much, Nancy. I'd like to turn it over to Jonathan. Jonathan, you've been a part of the indigent defense community for quite a while now. How has the evolution of your relationship with the SAA been from your perspective?
Thanks, and thanks for having me, and thanks, Nancy, for highlighting what is a really good working relationship right now. I think Nancy's comments did highlight some of the real obstacles up front, and I imagine that these are things that are at play in a lot of other states as well. The first is there is a real cultural issue, at least in places like Michigan where the grant funding comes out of the law enforcement community. You know, it's from the front end, the goals aren't quite the same. Obviously, for indigent defense, our focus is very much on what is the best for our client population and what policies can move, you know, their critical needs ahead in terms of the Sixth Amendment obligation for folks to have counsel when accused of criminal charges, and that very much is what centers a lot of our culture. So when that is mixed with law enforcement, even from a larger criminal justice standpoint, that doesn't always mesh. So it is seen, and Nancy's exactly right, in that it's seen as a departure from standard funding. And I was at that strategic planning session in 2013, and from an indigent defense perspective, it was sort of tough because it was various police agencies talking about law enforcement plans and priorities, and then followed by the Appellate Defender Office speaking about their Byrne JAG project that obviously had a very different focus. So I think it's important to know going in that there is this cultural difference, and for there just to be an acknowledgement by all parties that it's there, and that within that cultural difference, common ground can definitely be found on particular projects and working together, but it is going to inform, and it certainly did here, some of the early cooperation and working together. I think the second thing that Nancy highlighted was getting in the mix and what a challenge that was. It was very easy for me when I was at the Michigan Indigent Defense Commission to have a good meeting with my staff and with Nancy and her staff, and to talk about potential future projects and ways we would cooperate. But in a lot of ways, that's because some of the hard work had already been done, and it was difficult from the indigent defense side to get to become part of the Byrne JAG project in Michigan, and to get into this process where the folks who'd been funding had been, for the most part, police agencies, some prosecuting agencies, and some state court administrative projects, but very much the policing agencies. And so it did take a lot of working to get there through a lot of different means, some political, some administrative, some through, in Michigan, the judicial branch, some through the executive branch, some through, of course, meetings that were necessary. But it wasn't an easy process, and I'm glad now everybody does have a really good relationship. But it is important to keep in mind that at least in Michigan, when it was something very new for indigent defense to come into the mix, and it wasn't always smooth sailing getting there. I think the third thing to realize is, as Nancy said again, that there were definitely growing pains as this started, and as initially there were some projects and then a transition to, okay, what are the sort of projects that are going to resonate well with the coordinator of the state funding, and that also very nicely meet indigent defense goals. So there were some growing pains there, figuring out what the priorities were, and it's still a process. I think the fourth thing that really comes to mind for me in thinking about it is that even though the relationship is very good now, this is a process that's nowhere near over. And from our perspective, yes, there are so many different agencies in the state that are deserving in funding, but we like to look at it less as, all right, there are 800 law enforcement agencies and 1 indigent defense, or now in Michigan 2 indigent defense agencies. For us, it's more along the lines of, okay, there are 50% of this is the prosecution function, or maybe a bit more if you add charging to the mix, and that's prosecution and policing. Then there's some percentage that's the court function, and then there's an equally large percentage that's the indigent defense function. So we like our goals over the long term to look at this as a ratio of less 800 agencies, and 1 of which is, or 2 of which are the Appellate Defender Office and the Indigent Defense Commission, but instead to look at this as much more, all right, there's the prosecution and law enforcement focus, and there's also the indigent defense focus. And I think going forward from the indigent defense end, I think the first obstacle we're very much in a good place on, and that's having a good relationship and having an understanding that indigent defense funding is very much in the mix. But the second piece we're very much starting on, and that's figuring out what exactly the appropriate percentage is and how indigent defense gets treated fairly, and how hopefully long-term. Right now, the state of Michigan has 2 state indigent defense agencies, the Appellate Defender Office and the Commission, and how they can both hopefully receive some sort of funding. And then the last piece I wanted to highlight, and Nancy got at this a little too, it's so important just to speak the same language in terms of both process and implementation of projects, and also in terms of the overall project. So for process and implementation, it's been so valuable that our staff has worked well together, and that the research and administration folks at the Indigent Defense Commission, as I was transitioning and leaving there, met with Nancy and her staff and had a great meeting because the relationship was there. And at the Appellate Defender Office, I know the finance person here and the administration person here and grant maker here have been working for years very well with Nancy and her shop. So when there's cooperation on the administrative piece, some of the big picture issues flow very nicely. And then it's also obviously important just to speak the same language in terms of projects. So I'll talk in a few minutes a little bit more about the sort of projects that have been funded, and this is the slide that Nancy has now. But very much as this continues to develop, we want projects that are data-focused, projects that folks in other communities, the court administrative, the law enforcement community can appreciate as important, and so that these are projects that from our end are critical client-centered projects, but from their end are projects that are part of the larger criminal justice picture and process.
Great, thank you so much, Jonathan. And I definitely do want to discuss with both of you the projects you've been able to collaborate on. But before doing that, I would really like to unpack the issue that Jonathan brought up about growing pains, because I think there are many SAAs and indigent defense representatives who can relate to that feeling of it being hard to figure out how to speak the same language. So Nancy, what were differences that you made in the ways that you approached the indigent defense community based on the growing pains and the response you were getting from the indigent defense community about what Jonathan was touching on, there being differences in culture? Were there ways that you changed the way you approached the indigent defense community based on those differences?
I think we both just came to a mutual understanding. I don't know if we changed things right away, but we had a ton of meetings with them to make sure that we each understood what the others wanted, what their main goal was, and then for us to be able to share with them how they could maybe integrate better with the criminal justice programs that we were funding, and then for them to share with us why it was important for them to have grant funding that helps the criminal justice process as well. So, you know, it was a lot of communication and understanding. Now, we've gotten to the point where we meet with them way before our grants even open, kind of ask them what they have in mind, which we just did a couple weeks ago. And then they give us some options, and we, you know, select which ones we think would be best, give them some suggestions. They come back to us. It's a real working relationship, and we come to that mutual agreement that, okay, we think this is good and you think this is good, but it's not really where either of us started, but we're both good with that.
Great, thank you so much, Nancy. So Jonathan, I would like to give you, I'd like to give both of you, both Nancy and Jonathan, an opportunity to talk about some of the examples of collaboration you've engaged in and the various roles that you've played in that collaboration.
Sure. From my end, the projects that I feel like have worked the best for this are ones that that either are one-time projects where there's a need and that need needs to be filled, or else projects that are almost experimental in a way of figuring out what best practices are. And when those projects hopefully succeed, then a case can be made to make those projects permanent. So what we realized early on would not work well would be projects that would supplement what, and in this case it's when I was Deputy Director at the State Appellate Defender Office, projects that would supplement what what SATO was already doing, because that's part of the general fund. That isn't a justification for this new special funding. So with that in mind, that the projects that worked were either experimental best practices type projects or one-time projects. There are a number of good examples that are on this slide. One was the crime lab unit. This was the first major one that we did with Byrne JAG. There was a crisis in Detroit where the crime lab closed because of unreliable ballistics evidence matching, for example, a firearm that was used in a shooting to a firearm that somebody might have possessed. And that evidence was shown to be just completely unreliable in terms of what the processes and methods of the Detroit Crime Lab, and it led to the closure of the Detroit Crime Lab. At SATO, we saw, to the credit of the prosecution, a real effort to do something about it and review old cases, but we felt like this was only part of the picture. And to really do it right, to complement that, there needed to be communication and a review of every conviction from the client side, and to interview folks who had been convicted, to look through those cases and to work with the prosecution as to what should happen when ballistics played a role there. This was something that, sure, SATO could spend some volunteer time on, but we really didn't have the resources to take on aside from the day-to-day, beyond the day-to-day mandate of the office to represent folks appealing their convictions. So we made a case for why there needed to be defense involvement in the crime lab review. We received funding for a few full-time attorneys who put together a unit and a number of volunteers, and something in the neighborhood of over 5,000 cases were reviewed over a number of years. And as a result of that review, there were, I think it ended up being about 10 new convictions that were agreed to with the Wayne County Prosecutor's Office, another 1 or 2 that were resolved through litigation, and a couple of actual innocence cases in the mix. And it was a one-time need where we were able to make the case that the defense needed to be involved in this larger criminal justice issue, and then we were able to gather data for how it worked. So it became, I think it was initially a 2-year project, and then we were able to get funding once we showed how successful it was, funding from another source to keep it going for the years that were needed to review every single cases. So I would call that a project where, even though it was short-term, it was one where the data collected made the case for funding that would go on a few more years after the Byrne JAG project. There are 2 more that fit into this category of best practices type projects where we're able to get more or are in the process of hopefully getting more permanent funding for. One was a social work project, which is a standard thing in a lot of well-functioning trial defender offices. There's a social worker who helps to represent clients and to figure out everything ranging from reentry strategies to clients to mitigation evidence for clients. But it's not really been something that's been part of the appellate landscape for how social workers can help on appeal. And there's several ways that can happen. One is through collecting, making a case for reentry when there's a new sentencing for a client. Another might be to present mitigation for resentencing for a client. And a third may be in tune with some trial issues to really get to the bottom of some problems that might have been in the trial as well. And so we had a social work project through the Byrne JAG. It was through a couple of years, and again, we were able to collect data on how that project was successful in reducing sentences of clients. There would be a sentencing error, like let's say a sentencing guidelines problem, that would lead to a new sentencing hearing, and instead of the expected 1-year cut, we would often see 4 or 5-year time cuts because of the involvement of a social worker in these projects. And we were able in this way often to get prosecution on board and the courts on board, to showing that this was a project, a defense side project, but really where the whole criminal justice system benefited, and where the efforts of the social worker demonstrated that a real mistake had been made and somebody should get relief upon when there was a resentencing anyway. So through that, we were able to make a case to the state legislature, and now a social worker is a permanent part of the practice at the Appellate Defender Office. The most recent project is something along those lines too. It's called the Appellate Investigator Project, and again, it's the sort of thing that's more standard in other places, and that is, or actually it's more standard in the defender office, and in both trial and appellate level defender offices, you see a very active investigation unit. That's certainly been the case at the appellate defender office, but something you see less of is an investigator that helps assign counsel systems, and that works with private attorneys who are on a roster representing indigent defense clients. And SATA was able to promote a Byrne JAG grant that received investigative support for the roster. That's the rest of the appellate indigent defense clients that aren't the ones covered by the public defender side of SATA, the ones instead covered by the assigned counsel side. And that's been a very successful project with a number of good investigations and relief for clients. And again, we're hoping that because of the data collected by that can be a permanent part of the office. So that's the first major piece, is sort of best practices and experimental projects that make the case for hopefully permanent funding. And then the second piece, and I won't get into the examples so much, I already talked about a little bit in the crime lab context, are one-time projects, just needs that need to be filled, and this is a good way to do it. And I think the combination of having a defender system that has that the bread and butter of their work is the standard indigent defense work for clients and their representation, either on a trial and appeal, but that's really complemented by experimental projects that can seek permanent funding. I think that's a really good way to go, and it's something that the Michigan Indigent Defense Commission is doing as well in terms of day-to-day funding as it gets underway of trial-level systems, but at the same way promoting some good experimental projects. And I think that model of the Byrne JAG process helped to inform that.
Great. Thank you so much, Jonathan. What an impressive resume of collaboration between the SAAs and indigent defense community for a state that not that many years ago was struggling to figure out how to work together. Jonathan, you mentioned that one of your projects, you were able to identify a funding source that allowed to extend that project for an extra year. Was that Byrne JAG funding that extended the project, or another source?
That was another source. So we did the social work project, I think, and ended up getting started with Byrne JAG, and then also there were some bridge funds at the end of the process. But the primary funds for that and the way that project functions now is through the legislature. So Byrne JAG allowed the case to be made, and now it's a permanent part of the office. The crime lab funding was, I think, 1 year through Byrne JAG, and then that project needed another 4 years or so, and that we were able to get partly through the state legislature and partly through, actually it was Recovery Act money. But the initial case, again, was made through Byrne JAG.
Great, thank you so much. And so Nancy, we have this slide up of all these different examples of collaboration that you've been able to do with the indigent defense community. What has it been like to collaborate on these projects, and what lessons would you say you've learned from that process?
You know, I think, as I mentioned before, we have learned, I mean, they are great grantees. They do, once they create their project and, you know, propose it, they really are, they get very into it. They do great reports. They, you know, as I said, they're great grantees. There's no issues with that. And I think, as I emphasized, it's the communication and the willingness to come to a mutual agreement that would be the most important for anyone.
Great, thanks. And so Nancy and Jonathan, what did the two of you make of the new JFAA language regarding strategic planning? How does it relate to the work you've been doing together already in Michigan?
So from my end, I'm just very excited. And to Nancy's credit, she mentioned in 2013 that at that point, that was before the Indigent Defense Commission was operating, but Nancy invited SATO to be part of a large strategic planning session. But I'm excited to see it sort of in paper, that there is a strategic planning requirement now, and that indigent defense is part of that. So I think that piece is something I'm looking forward to for the indigent defense side to be part of that planning process, and to keep making the case that I've talked about already, that it's wonderful that we've got some subset of projects up and running and great communication on those projects, but why the indigent defense slice of the pie is increasingly important. So I look forward to that in the strategic planning piece.
Great, thank you, Jonathan. And so Deb, what resources does NCJA have to offer SAAs and defenders who are working to forge a collaborative relationship with each other?
So that's one of the neat things about this TTA project, is that NCJA is available to the SAA to help them engage new stakeholders. If they've not worked with indigent defense in the past, or if they've maybe had a fairly narrow group that's been involved with their planning, these training and technical assistance resources from NCJA are available to help them kind of figure out how to navigate that and build the relationship that Jonathan and Nancy just talked about. So that TTA is available to all of the SAAs across the country, and they are more than welcome to reach out to us through our website or on the contact information that's available.
Great, thank you so much, Deb. Well, what an inspiring story of the Michigan community coming together to figure out, to get through the growing pains of building a relationship between SAAs and the indigent defense community. And this story makes it clear that it's not always easy, but as we look at this long list of productive and positive projects that the SAAs and the indigent defense community have worked on together in Michigan, it's clear that it was definitely worth it. And it's great to know that NCJA is there to ensure that communities who are working on building these collaborations don't have to do it alone. So with the last 10 minutes of our time, we will open it up to questions and answers. Again, feel free to type in your questions in the question box on the lower right-hand side of the screen. I'll wait a few minutes to collect some questions, and I'll read them out and pose them to our panelists. So we got a question from someone asking if the PowerPoint can be emailed to them, and yes, the recording of the entire webinar along with the PowerPoint slides will be emailed to all of the participants. All right, I think that's it for questions and answers. Nancy, Jonathan, or Deb, do any of you have any closing remarks?
No, just thanks for the opportunity, Zoe. This has been a great panel.
Great. We actually just did get 2 questions. So one question is, what is the opinion of SAAs towards funding training programs? Nancy, how do you feel, what's your perspective on funding defender training programs?
I think we have funded training programs, and we're willing to do that. I think, as I said, I don't have my list right in front of me, but I know we have funded training programs in the past, and if those can be demonstrated to help, you know, the larger criminal justice community, then we're all for it.
Great, thank you, Nancy. We got another question asking, is there a certain amount of JAG funding that needs to be dedicated to indigent defense, or does indigent defense just need to be a part of the strategic planning?
Zoe, there isn't a formula for how to allocate across purpose areas. What is specified in the Act is that there must be data to support how that funding is allocated. So it doesn't say necessarily that across those 8 purpose areas you have to divide it evenly or proportionately. It just says that you should be using evidence to inform how you do that resource allocation. So if the need is there, then it certainly is an allowable and justifiable use of the funds.
All right, I'll just give 1 more minute because it sounds like someone might be typing in another question. Deb, we've gotten another question about how much money is available for each state. How is that allocated under the Byrne JAG grant funding?
So the Byrne JAG formula grants are based on a formula that looks at population for the states and also crime data that is submitted across the country. So it's different for every state. Individuals who have a question should contact their local SAA to find out what that allocation is for their state, but it varies widely across the states depending on population and crime statistics.
Deb, what role can strategic planning play in allowing the indigent defense community to break into the funding pool?
I think strategic planning provides a really great opportunity for all of the partners across that whole justice continuum to meet together to talk about this system. As I said during my presentation, oftentimes different agencies tend to get that compartmentalized view of just their own sector, whether it's just corrections or just defense. And the planning process is really designed to talk across those lines and not just within the individual silos. So I think it's a great opportunity for the providers of defense services to share some of the challenges and strengths that they bring to the justice system that perhaps some of the other partners are not aware of or less aware of, and that can help to really move system change. So I think that the planning process provides a great foundation for building the relationship that they've demonstrated in Michigan, and provides, I think, a great opportunity just to start that conversation.
Great. Thank you so much, Deb. We have two more questions, and then we're going to wrap it up. One question was, will comprehensive strategic planning be required starting for JAG fiscal year 2019 applicants, or is it retrospectively required for prior fiscal years?
The requirement as a result of the JFAA changes is for fiscal year 19. We do believe there will be some language related to the comprehensive planning in fiscal year 18, but it's not mandatory until 19 and then going forward from there.
Great, thanks so much, Deb. And finally, we have a question asking, Jonathan, can you provide the communication methods you used regarding the data that you provided to make the case and obtain funding from the legislature?
Sure. I could dig that up. It's a number of fact sheets that we put together for the social work project. It was very much what we did is we demonstrated how many years we cut off our clients' sentences, and then we would compare that to costs of incarceration. And then we made the case that we were saving the state a lot of, in addition to obviously the human costs to, on our clients, but that there were huge costs to the states from these errors that a social worker could help fix. So that was our approach.
Great, thank you. And Jonathan, if you have anything summarizing your fact sheets, if you want to send those to me, I'd be happy to send them out to all of the participants. In addition, as I mentioned, we will be sending out a link to the recording of the webinar and the PowerPoint slides to everyone who participated. Thank you all so much for attending our webinar. We have shared our contact information both for us at the Justice Programs Office and NCJA, the TTA providers. So feel free to jot that down and be in touch with us in the future if you have any follow-up questions. Thank you all so much and have a great day.